5 seconds to go. Start. In view of the above mentioned judgments, it is apparent that the view taken by the court is applicable to the instant suit. The MOU in the instant suit was executed in the year 1998. Since then, almost 25 years have elapsed. The performance of the contract would involve considerable hardship on the parties. The same is being said considering that a third party interest has been created to such an extent that the revocation of that contract would lead to an increase in hardships warranting unjustified litigations. In view of the material which has been placed on record, it is indicated that a third party interest has been created in the property against which the plaintiff is seeking specific performance. Such a circumstance makes it inequitable to grant and enforce the specific performance decree. The said observation is made to balance the interests of justice and equity for the parties involved. Hence, the decree for specific performance is not to be granted. This court is further of the view that there will be undue hardship caused to the defendant as well as to the third party who purchased the property in dispute in case the plaintiff is granted specific performance. Taking into consideration the facts of the case, this court is of the view that the plaintiff may have been entitled to the relief as claimed for specific performance in the year 2004. However, presently the plaintiff cannot be granted the relief of specific performance by this court due to the defendant's conduct of not adhering to the terms of the MOU entered into between him and the plaintiff's creation of third party interests and the other factors involved as discussed herein above. PW4 Shrimati Pratima Debnath, who used to look after Prabha Ranjan Das, has in no uncertain terms deposed that the defendants did not stay with Mr. Prabha Ranjan Das. The defendants used to stay at Beltali, AD Nagar, which was her parental house. According to PW4, the defendants used to come and visit Mr. Prabha Ranjan Das and stayed in the suit property for a day or two. PW4 has also deposed that even when Prabha Ranjan Das was ill, the defendant number 1, that is his wife, did not bother to come and see her husband, and the PW4 would help him for his medical treatment. The PW4 has further deposed that she was aware of the agreement of sale and receiving of earnest amount from the plaintiff and was aware of the fact that the balance amount would be paid within 3 months and the sale deed would be executed and registered. The trial court, vide judgment and order dated 20th November 2018, has held that the plaintiff is entitled to get a decree for specific performance of contract and accordingly decreed the suit in favor of the plaintiff on 23rd November 2018. The trial court held that the defendants failed to establish that the suit property was mortgaged to the Agartala Cooperative Urban Bank Limited and they were not necessary parties to the suit. The suit in question was filed within limitation. The registered agreement of sale dated 27th May 2016 was signed by Mr. Prabha Ranjan Das himself and the same was identified by PW2 and PW3 respectively attesting witnesses. Prabha Ranjan Das was mentally fit at the time of signing and registration of the agreement of sale. The defendants lead no evidence or produced any document to their claim that Prabha Ranjan Das was mentally unfit to give effect to the transaction. plaintiff was always ready and willing to perform his part of the contract. Defendants failed to prove that the performance of a contract would involve hardship on them, which Prabharanjan Das had not foreseen at the time of execution of the agreement of sale subsequent to the contract from any act of the plaintiff. The trial court, after dealing with all the issues so framed, came to the conclusion that since the defendants were not residing with deceased Prabha Ranjan Das during his lifetime, therefore no hardship would be caused to the defendants if they are asked to execute the sale deed in favor of the plaintiff. The trial court was right in holding that no hardship had resulted from any of the acts of the plaintiff post execution of the contract. In the instant case, the defendants have failed to show any circumstance existing at the time of the contract that if the suit land was sold, it would cause hardship to them and they would become homeless. The trial court rightly decreed the suit and directed the defendants to execute the registered sale deed in favor of the plaintiff upon receipt of balance consideration amount of rupees 13.50 lakhs and also to hand over the vacant and peaceful possession of the suit land after execution of the sale deed. The High Court, while setting aside the judgment and decree passed by the trial court, failed to consider Section 22B of the Specific Relief Act 1963 and wrongly concluded that it will cause hardship to the defendants because such performance of contract would render the defendants homeless, being conscious of the fact that the defendants were residing in the parental house of defendant number 1 at Beltali AD Nagar, which she has mentioned and admitted in her examination in chief filed by way of affidavit. In such circumstances referred to above, the learned counsel appearing for the appellant prayed that there being merit in his appeal, the same may be allowed and the impugned judgment of the High Court may be set aside. It is not in dispute that Prabha Ranjan Das, the husband of defendant number 1 and the father of defendant number 2, signed the Bena Patra on 27th May 2016, which was registered on 28th May 2016 for the sale of suit property residential house while he was ailing and he died on 5th July 2016 and he had no other property to offer to the defendants to reside. The defendants are the legal heirs of late Prabha Ranjan Das, wife and minor son. An amount of rupees 4 lakh was received by check by late Prabha Ranjan Das as advance towards the total sale consideration of rupees 17 lakh 50,000. In the written statement filed by the defendants, it was specifically pleaded that if the suit premises were to be handed over to the plaintiff pursuant to the subject agreement for sale, the defendants would be rendered shelterless and therefore it was prayed that it was a fit case to deny the relief of specific performance. The trial court failed to frame the issue regarding the readiness and willingness on the part of plaintiff to perform his part of the contract. In support of the aforesaid submissions, the learned counsel placed reliance on the following decisions. In such circumstances referred to above, the learned counsel prayed that there being no merit in this appeal, the same may dismissed. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is whether the High Court committed any error in passing the impugned judgment. Stop.